Hey, welcome back everyone for our third ERISA webinar. Before we get started today, I just want to remind everyone that they can go to our website and rewatch any webinars or catch up on ones you may have missed. That's www.mwl-law.com. Click on webinars, and you'll also find a wealth of other resources there for you to enjoy. But today is all about the numbers. We're gonna really hit the math today. Those numbers are 5,500 and 1024. Catherine's gonna really take the lead here and walk us all through the ins and outs of Form 5500s. What do they really show? What are the common errors, and how significant are they when it comes to proving basically whether your plan is self-funded or not? Next, Nancy and I are going to tackle 29 USC 1024 and address some of the requirements relating to furnishing the plan under subsection B1 and responding to document requests under subsection B4. So without further ado, let's kick it over to Catherine, who's going to enlighten us all about the Form 5500.
Okay. Good afternoon, everybody. So I am very confident that if you've dealt with self-funded ERISA plans before, you've dealt with plenty of requests, not only for documents, but for the 5500 specifically. So very basically, the 5500 is a tax filing that the employer files. Unlike your personal taxes, they have until July 21st to file every year. And so one of the common issues I see is attorneys saying, well, I want the 5,500 for the year where the accident happened. Well, if you're dealing with a January or a February loss, that's going to be pretty tricky because you're not going to have one for likely 18 months. The 5500s are publicly available. You can actually get them on the Department of Labor's website. They keep a database of them. It goes back pretty far. I have found that that's far more complete than sites like Free ERISA, which, you know, when I started in this industry was the only resource. And when you're searching, one thing to keep in mind, if you're conducting a search for these and you're not just getting them for the plan or getting them from your client, if you've got the plan's EIN number, which is usually in the plan document somewhere, that tends to be the best way to search. It helps when a plan has a common name, and so maybe you're getting a lot of results that aren't actually for your employer. And it can really help if the plan either has a name that has a symbol in it or a spacing in it where you're not quite sure where to put those characters for their legal name, or if you're dealing with a plan that has a subsidiary or a parent corporation where the 5500 is filed under one of those, and so you're having trouble locating it. It's also the best way to know that you're just absolutely looking at the 5500 that goes with your plan document. One other thing to keep in mind is that for welfare benefit plans specifically, so for health benefits, not every plan needs to file. If you've got under 100 participants at the beginning of the plan year and the funding comes solely from the general assets of the sponsor, those plans are exempt from the 5500 filing requirement and obviously from various requirements to provide a 5500 to plan participants since one doesn't exist. Something to keep in mind, though, is that that employer may need to file a 5500 or a 5500 short form for some of its other plans. So we very commonly see for these smaller plans, they still may file one for, let's say, their 401k plan, which can be helpful to you just because you're not trying to recover for a 401k plan. That filing is still going to give you some indication of the number of participants in the plan. And so if you're seeing that they only have 30 or 40 participants, that's a good indication that they're probably exempt from the filing requirement for the welfare benefit plan. Though obviously if your case is going to litigation, that's something that you're probably going to want to confirm with the plan itself.
Yeah, make sure to jot down that regulation there that she cited, because if you tell plaintiff's counsel that, you know, hey, we're exempt, he won't be able to find where that is, and you're gonna go back and forth with that attorney over, the fact that there's no 5,500. That, of course, he's going to say that that means that you can't recover. You're not ERISA. So that regulation is a helpful one to pull up.
And so going into what counsel is going to tell you when they can't find a 5,500 or when they see something on the 5,500 that they don't like, are the 5,500s absolute proof of a plan's self-funded status? They absolutely aren't. So this is a quote from the US GAO from a report that they authored in 2014. We and the filing community have also found aspects of the form to be burdensome to complete and difficult to interpret. One of the things that we see a lot are there's some common confusion about filing. So for example, how to identify stop loss, how to identify a TPA, whether or not to check that, dreaded box 9 insurance checkbox at all. And so what a lot of government agencies have told us is basically that they're finding a lot of inconsistencies that aren't making the forms very useful in terms of generating data on whether or not a plan is self-funded. So here are some quotes from the Department of Labor. The Form 5500 does not explicitly disclose whether a health plan is self-funded. The Department of Labor since 2011 has been trying to generate an algorithm that would allow them to essentially look at all the 5500s, look at the data set that are all 5500s filed so that they can try to get a better sense of what number of plans are self-insured, what number of, people are on self-insured plans. And they have been tweaking that algorithm since they created it because they're trying to morph it into an understanding of, as they put it, how the self-insured group health plans actually file those forms, because the regulations simply aren't as clear as they would need to be in order to generate the data that a lot of those government entities are looking for. And this is from a report that the Department of Labor generated, specifically talking about, Schedule A's, which we're going to get into detail about in a minute, are intended to report on insurance contracts. Some plans attach a Schedule A for a contract that appears to be for administrative services only rather than for insurance. Given these limitations, the classification in this report should not be interpreted as an official or legal definition. So what this is talking about is specifically where we see scenarios where a plan will file a 5500 that identifies a TPA or some other entity that's providing administrative services to the plan as an insurer that's providing benefits, which of course we know they aren't, but when you file those kind of Schedule A's, it can create a lot of headaches and a lot of confusion both for you and for plaintiff's counsel. So let's take a look at an actual 5500. So for anyone who is interested in playing along at home, I have the EIN number for the 5500 that I'm using in these slides, and this is from their 2016 filing. If you'd like to get a sense of where all these pieces actually fall on the form itself, but I've tried to make sure that I include, what box number I've taken a copy paste from. So the very top of the 5500 is something that you'll all be familiar with. It'll explain the year for which it's been filed and the calendar or fiscal plan year that it covers. And so one of the reasons that I like to pay attention to the bit at this very top is that some plans don't follow calendar years. We've dealt with plenty of plans where their plan year starts in June or July, or for one reason or another, the plan chose to, I've definitely dealt with plans who choose to become self-funded rather abruptly. And so the first year that they file a 5500, it may just be for October to December before they switch over to a more regular filing schedule. So pay attention to those dates because they can be really important for your case, especially if a plan has only recently become self-funded. One of the things that you're going to want to take a look at to make sure that you're looking at the right document, that you're not looking at one for a pension plan or for a 401k plan or something like that, is box 8B, which isn't something that I see a lot of people referring to. And so what the numbers under box B mean, those are all coded. So 4A means that the plan is offering health benefits. Some other common ones that we'll see are for dental, vision, temporary disability, long-term disability, and things like that. But if you're trying to recover for a lien for health benefits and you don't see 4A in box 8B, you are almost certainly looking at the wrong document, or there's been a more substantial bit of confusion about filing than even you'll see in the typical. So make sure that you've got 4A on there so that you're looking at the right document. The other thing I just want to show you is that part 2 will have basic plan information. This is the stuff in the upper right-hand corner. I have no idea if you guys can see my mouse. And that'll just have information like who the plan sponsor is, what their address is, and again, that EIN number. And so if you're being sent to 5500, those are ways to confirm that you're looking at ones for the correct plan. Boxes 5 and 6 are also pretty important, only because that's going to give you data on the total number of plan participants, which can be incredibly important once we start digging through those Schedule A's. And so those are on the first page of the main 5500. The main 5500 is just that 3-page document. Obviously, when you go to the Department of Labor's website, you're going to pull some documents that are 30, 40. I've pulled 5500s that are 200 pages long. And so the main 5500 is just those first 3 pages. And so now we're getting to that box that we know opposing counsel is gonna point to in every single case. And they're gonna look at the plan's funding arrangement and the plan benefit arrangements. And in most cases, what you want to see are that the plan benefits are funded through a trust or through general assets of the sponsor. And so usually you're going to see at least one of those boxes checked. If neither of those boxes are checked, you're going to need to have a conversation with the plan about whether they potentially need to amend their 5500. Maybe there's confusion about how they actually do fund their plan. But if neither of those boxes are checked, that means you need to have a conversation. What we most commonly see is something like what I've got up on the screen, which is where you've got general assets of the sponsor checked, as well as insurance. And so that goes back to the information that I was showing you in box 8, all those codes. So a plan filing a 5500 may be providing that 5500 for any number of benefits that it offers. So it has health benefits that are self-funded, but it goes fully funded for dental. It is perfectly appropriate to check off both general assets of the sponsor, because that's how you fund the health plan, as well as insurance, because that's how the dental benefits are provided. And so box 9 is really just the beginning. The fact that insurance is checked is not the end-all be-all that a lot of plaintiffs' counsel will make it out to be. What it means is that you need to do further investigation and you need to dig into those Schedule A's. And so box 10 will usually show that insurance information is provided in a Schedule A. So the Schedule A itself is a 4-page document. Usually there are going to be multiple ones attached to the 5500 itself. And so for every single Schedule A that's been filed, on the last page, you're going to see Part 3, Box 8. And that's going to be your starting point, because it lists off all of the different kinds of coverage that might be provided through those insurance contracts. And so most of them, for the sake of recovering health benefits, are going to be completely irrelevant, because you're not trying to recover benefits for vision or for temporary disability. And so hopefully with the 5,500 that you've got, all it has checked is something that isn't relevant to the benefits that you're trying to recover for. And so you can point out to opposing counsel, hey, if you look at the Schedule A, they're only insured for dental benefits, and we're not trying to recover those. Obviously, we'll also see a lot that have stop loss checked. And so you should definitely tune in for our next webinar if you need some help convincing opposing counsel that stop loss doesn't have any impact on the plan's self-funded status. But obviously it doesn't. And so if the stop loss box is checked, that shouldn't be a problem either. The times where we really run into issues are where they've checked the health box, or there's an HMO or a PPO box checked, because that indicates that the plan might be funding some of its benefits directly to participants through an insurance policy. There we go. So if you're looking at the full 5,500, these boxes are from pages 8 to 11, and specifically deal with an insurance policy that this plan purchased through Blue Cross Blue Shield of Hawaii. So the policy covers the full policy year, but it only covers 149 participants, which is really important because if you remember back on the main 5,500, we're looking at a plan that covers over 5,000 individuals. And so what's important to note here is that while the plan may be providing insurance benefits, they're not necessarily providing it for everybody. And so this plan in particular is happened to be providing it. They were a West Coast plan, but they also had some employees who were based in Hawaii. And so many of those individuals ended up on a fully insured policy. What you want to be thinking about if you're dealing with a plan that has that level of complexity is, first off, explaining to opposing counsel, oftentimes you're going to be involved because you're working with a particular TPA. And so if the benefits are being processed through that TPA rather than through an insurance company, that's one indication that the person that you're trying to recover the lien for isn't covered on, say, the Blue Cross Blue Shield of Hawaii plan. But the other thing that you may need to be thinking about is going to your client and getting an affidavit saying, look, this specific participant is covered under our self-funded offering rather than under our fully funded offering, even though we do offer those benefits to other employees. And so you'll see in that box 8 that this has been properly designated that they are providing health benefits to those 149 employees through an actual policy of insurance. And so that's something that if you're trying to recover for one of the self-funded patients, that you're going to need to go through and explain to opposing counsel. So what if your 5,500 is actually filled out incorrectly? What if it tells the Department of Labor, the IRS, the world, that your TPA is actually a health insurance policy that's funding your benefits?
Catherine, just before you jump in, how often is it, at least on our end, that we're seeing mistakes or errors in the 5,500? Do you have a percentage, or just based on what you're looking at? I mean, in other words, in my experience, it's not infrequent. Like, there are pretty common regular filing mistakes, right?
Absolutely. It's on a ton of cases that get referred to our office, and actually these kind of confusion over 5,500s are some of the things that can commonly lead to a case needing to be litigated rather than being able to be resolved more amicably, because now counsel has something to hold on to say, look, there really is ambiguity about how your plan is funded. You're representing that your TPA is actually providing health insurance benefits, which can only be more confusing if, for example, your TPA is a company or a common name in the insurance industry and has fully funded plans.
Right, and I mean, we've even seen as much as a case where not only did they hold on to that, but they then, after we had to file suit, sued us for fraud, saying that, yeah, we have this was no simple mistake. This was intentionally. You're going out there subrogating as self-funded, but you're really fully insured. That's fraud.
Exactly. And so you can see a lot of really unique claims. And so if you've got a 5500 that's filled out incorrectly, first off, obviously you want to know if the 5500 is filled out incorrectly early on in your case, and you want to be talking to the plan about whether or not they're going to be amenable to amending their 5500. Well, technically a 5500 being filled out incorrectly doesn't void the lien. It doesn't technically impact whether or not they're self-funded. That's still something that you can prove in discovery by providing copies of checks. It does mean that discovery is going to be a lot more intensive because now there are all these open questions. And I think most importantly for a lot of our clients, we deal with a lot of clients who rely either under ERISA or under the plan terms to try to get attorneys' fees and costs for a lot of these cases. They try to say that, the participant should be repaying us. They shouldn't be making us fight for it. If your 5500 is filled out incorrectly, it is extremely unlikely that a court is going to award you those kinds of fees and costs because it was your plan's actions that created this ambiguity about the funding status because your basic documentation wasn't clear. Now, there are a lot of courts that have rejected these kind of generic arguments that counsel makes about, well, they checked the insurance box. If those aren't arguments that can ultimately be backed up with the evidence, the courts have generally been on the side of the plan of calling these arguments disingenuous, of pointing out that a lot of the arguments that are made don't necessarily indicate that there were health benefits being provided through an insurance policy. But these are cases that can really increase costs for plans if they're not making sure that the 5500s are correctly filled out on the front end. So if it is actually filled out incorrectly, and it's not just something that you need to explain to opposing counsel what all those Schedule A's mean, a common issue, like I said, is listing the stop loss of the TPA as a health insurer. You should be prepared to amend the filings. But another thing you can think of if opposing counsel is reasonable and receptive, which obviously not all of them are again going to those Schedule A's and trying to point out where errors are a little more obvious because of the confusing nature of the form. So one of the errors that I see where plans, I think they or their accounting firms are just trying to be extra complete, are where not only do they point out that they have a stop loss contract in box 8 by checking that little box I, which is perfectly reasonable, but they also check the health essentially because they're trying to indicate that the stop loss benefits are related to those self-funded health benefits that they provide. So I'm going to tell you these screenshots are from a different 5500 than I've been using for the rest of the slides. So this 334 number is actually the total number of the plan participants for this particular plan. And so one of the things that I had to try to explain to opposing counsel when he said, aha, Transamerica Life Insurance Company is providing your plan with both health insurance benefits and stop loss coverage, is if you look at boxes 9 and 10 on the Schedule A itself, one of the things that needs to be disclosed is the amount of premiums that are paid for whatever that insurance policy is. And so in this particular case, we're dealing with annual premiums of about $326,000 for 334 participants. And so if Transamerica was really providing health insurance to these people, they would be doing it for less than $1,000 per person per year, which is obviously not what health insurance remotely costs. And so this was one of the ways that I was able to convince counsel that this was really just a filing goof. They were trying to be over-inclusive and really ended up providing way more information that was helpful and causing all this confusion. But at least, you know, opposing counsel knew they were going to look a little silly trying to convince a court that the health plan was really getting some kind of actual health insurance that covered participants' claims for these rates. The rates definitely indicated that what we were actually working with was stop loss coverage.
Yeah, and these are important discussions to have if you've got a plaintiff's counsel who's raising these issues, is to educate and inform. Now, at the same time, if you're dealing with a lien resolution vendor, that they're not really interested in the truth, so you can probably forego most of those discussions because they're just throwing up roadblocks and they don't really care what you respond with. They're not actually interested in the truth or what the dial, you know, it's just, here, let's throw up a bunch of other things. Hopefully they don't know how to even read their own 5500 and they'll go agree to waiver or reduce the lien. That's their only interest. And, you know, they can certainly come on and explain themselves. We invite them to come on to a webinar if they want to clarify what they really are interested in. But that's, you know, again, you're going to get some traction with plaintiffs' attorneys who are really interested in finding out the truth versus just throwing roadblocks. But, you know, don't spend too much time worrying about this if you've got one of those vendors on it, because they're not interested.
So unless anybody's got any more questions about 5500s, I'm happy to answer. I think it's time to turn over the presentation.
So yeah, well, I do have one more thing, and we've had this happen. This is not that big of an event to amend, right? I mean, no. It's really just an electronic filing. You just got to get the right people on board. Oftentimes, it may be the broker that's preparing this, and so, you know, you just need to jump on with them and have them amend it. It's not really a big issue. But again, this is one of these things that I would recommend doing in advance rather than waiting for this to be a big issue. Preferably during the onboarding process is to take a look at the group's documents, to take a look at their 5500 and see where there might be issues. You know, that's just a lot easier than addressing it after the fact, after it's become a big issue. But why don't we turn to a related topic, these 1024 document requests. Let's start with Nancy. She's gonna cover kind of some of the more routine document requests that we're getting under subsection B4, and then I'll kind of come in at the end and explain the initial furnishing obligations that you have. Nancy?
Thank you, Ryan. Hello, everybody. Nancy Case, and we will be talking today about ERISA document requests, the kinds of requests that you'll be getting, and then how some ideas and best practices about how to respond to those requests. So really what we're trying to do also is avoid the $110 per day penalty that I'm sure that you've seen presented to you by plaintiff's counsel when you're trying to resolve your lien. So to that end, there's actually good news. So the first slide is while everyone was fighting COVID, homeschooling, or doing yoga at home, whatever they were doing, the 11th Circuit decided a very important case on this topic. On March 27th of 2020, the case of Williamson versus Travelport was decided. And this case clarified the scope of document requests that trigger the penalty provision in ERISA and the manner in which such requests must be made. So to go back to the statute, or to the section that imposes the sanction, it imposes the sanction for a plan administrator's failure or refusal to provide information that the plan administrators required by the subchapter to furnish to a participant. So the phrase "by the subchapter" applies to an administrator's requirement to provide that information identified in the ERISA statute 1024B4. So let's do some identifying. Slide 2. Okay, so 1024B4 requires specifically that the administrator shall Upon written request of any participant or beneficiary, furnish a copy of the latest updated summary plan description and the latest annual report, any terminal report, the bargaining agreement, trust agreement, contract, or other instruments under which the plan is established or operated. This is a very efficient and tidy statute with a lot of magic language that we'll cover briefly here and hopefully quickly so we can move on to Ryan's section. So number one, what is required is the latest updated summary plan description. So not years, this to that, it's the current and latest that can be found. Important caveat to that, because we all know what an SPD is, that under ERISA 502A3, which is the enforcement mechanism, a self-funded ERISA plan only has the authority to enforce the terms of the plan. But in order to determine the terms of the plan, the master plan document must be compared with the SPD in order to establish the obligations of the beneficiary. So you have to have the master plan document in order to do this evaluation. And the mechanism to obtain that document is this statute, 1024B4. So the educated plaintiff's attorney will not agree that the plan administrator has complied with 1024B4 until he or she has possession of both documents. So this is important. And the case that supports that is Cigna v. Amara. The U.S. Supreme Court stated that, taken together, we conclude that the summary documents, as important as they are, provide communication with beneficiaries about a plan, but that their statements alone do not themselves constitute the terms of the plan. So, in other words, you need the master plan document, if it exists, and the SPD to provide. So, number two, the latest annual report, which we just learned is the Form 5500. And you need to provide the latest that was filed, not whatever years come in the request. Then the statute states a terminal report. So what's a terminal report? It's only for labor organizations or unions who cease to exist. It's sort of like a final annual report. So most of the time you don't have to worry about that. Any bargaining agreement. Again, a union or a labor organization, it's an agreement with the benefit plan. So you might have to do a little bit of digging on that one. Next, a trust agreement, contract, or other instruments. And this can be a little bit tricky. So as Catherine pointed out, some plans are funded by a trust and that box is checked. And you can find that out either by the 5500 as Catherine described, or the SPD. If you search under funding, sometimes it will, the SPD will state that the funding is via a trust. But again, if you have the authority to respond to an ERISA document request, then you have the responsibility to get these documents from the plan administrators. And as Catherine suggested, get them on the front end. Don't wait until you get a request. It's just a lot easier that way and saves a lot of time. Moving on to contract. A contract that most applies in this situation is an administrative services agreement that describes, again, the funding status and the delegation of authority. So you may want to or need to produce that. Then we get to the other instrument, which in the past created some confusion. What is other instruments that establish or operate the plan? This case that we just talked about, if you've provided documents that allow the participant to determine the establishment and or operation of the plan, then no other documents are required. So the 11th Circuit confirmed that.
Sorry, Nancy, I just want to jump in there. So you mentioned the ASA and as possibly being a document that you want to produce.
Yes.
I think that generally, if we're dealing with a self-funded plan, that ASA isn't going to be one of those formal documents, but that doesn't mean it's one you might not want to produce, right? Because it also does confirm the fact that there is one, confirms that it's self-funded. So it actually helps you, even if it's a document that's maybe on the periphery that you don't have to produce, it's a helpful document for us.
Exactly. It'll get you where you want to go. You're trying to resolve this case, and the ASA will generally say, that there's a certain account that has been opened from which claims will be paid, and you have the plan has a responsibility to fund that account. It just neatly describes exactly how the plan is funded. So yes, very helpful document. But the 11th Circuit again confirmed that other instrument means formal legal documents governing the plan under which the plan is established or operated. So they're formal legal documents. You may get a laundry list of requests that are well outside the scope. You don't need to respond to those, but we'll get to that a little bit later on those best practices. So slide number 3, Williamson v. Travelport takeaways. This is a nice little case. So the 11th Circuit ruled that the penalties available under 1132C cannot be imposed for failure to provide documents other than those specifically enumerated in the 1024b4 statute. So it further clarified that the term other instruments is to be interpreted narrowly as formal legal documents governing the plan. And it doesn't simply refer to documents related to a plan. The 11th Circuit joined its sister circuits in holding that although a request for document need not name the precise document it seeks, because sometimes plan participants don't know what they're asking for necessarily, it must provide the claims administrator with clear notice of what is requested under the statute. So if you're careful in ensuring that the production of documents required, pardon me? Oh, Ryan, I thought you said something.
Nope.
If you're careful in ensuring that the production of documents required under the express terms of the statute, then arguably plan administrators can use this case to help fend off improper requests for sanctions related to other documents, and maybe even build a case for rare award of attorney's fees. So having said that, consider responding to document inquiries that are unclear by asking for clarification. So what you want to do is build a record. The requests as stated do not provide clear notice of the documents being sought. So next, let's take a look at a typical list of requests that you might get. Slide number 4. Okay, you might see something like this. Please send copies of the entire summary plan description and other plan documents relating to my client's health insurance coverage for the years 2013 to 2016. That's an example. Ding, ding, ding already, it's not health insurance coverage. Whether that's a mistake, you're dealing with someone who doesn't know what they're talking about. Whenever you see the word insurance and you're talking about a self-funded ERISA plan, you already know, proceed with caution, respond appropriately. Copies of the entire healthcare plan contract for the above referenced insurance plan for the years 2013 to 2016. Again, this is outside the scope, but this is likely what you'll see. Copies of the Form 5500, including all attached schedules filed with the U.S. Department of Labor for, again, a span of years. And we know we don't have to provide that. The next, an itemized list of payments for the above referenced plan paid for benefits which you maintain are related to the injury from this accident. Again, outside the scope, but you probably have already provided that anyway, or you will about to provide that is what you're claiming. Next, they'll ask for generally the administrative services contract prepared by the above referenced healthcare plan for the years X through X. We talked about that a little bit before, and again, we'll get to responses. Then they'll ask for copies of all contracts, including but not limited to insurance contracts, stop loss contracts, health insurance contracts, insurance intermediary services contracts. Sometimes I don't know where they get these laundry lists from, must be some other kind of seminar or webinar. For the years, again, 2013 to 2016. We'll get to responding to that. Any amendments to plan documents for the above reference plan, including but not limited to the summary plan description for the years X to X. And sort of along the same lines, copies of the SMM, summary of material modification statements for the years 2013 to 2016. And again, we'll get to responding to those, but if you we've dealt with some plans that like to amend every once in a while or often and like to amend the subrogation piece of it. That is something that is important. If you are providing the master plan document, amendments need to go along with that. So you want to make sure that you're asking for that. And then again, providing it to the participant in a relevant way. So now we move on to response considerations. So it'll be slide number 5. So assuming that you have authorization from the plan administrator to respond to these requests, 2 things to bear in mind. 1, stick to the statute. Discuss the statute, that is what you're responding with. And also stick to the facts. And your facts are review your letter carefully. What are they asking for, and break it down, because you're going to want to respond to the correct parts of what the request is, and also address the requests that are outside of the scope. So you want to say something like this. and just sort of a laundry list of what I like to include in letters. I am writing on behalf of XXX plan administrator in its role as the plan administrator of the name of the plan. Try to get all of this right. Don't be casual about it. Get the actual name of the plan and its structure. Then you want to say this correspondence responds to your letter on behalf of the participant claimant requesting certain documents related to the plan. Self-explanatory. Your letter is dated, whatever it's dated, and was received by the plan administrator on this date. Could be important down the road. The statute requires a 30-day response time, and we'll get a little bit later to why that's been told at the moment, but you want to make sure that you're documenting the date of the letter and the date the plan administrator received the letter. The next piece, because the statute requires that the request be made by a plan participant, you'll want to say your letter, it's coming from an attorney, did or did not provide a written authorization signed by the claimant or the plan participant. You just want to state that outright. And then you'll say, because usually that's not included, you'll say, nonetheless, the documents described herein are being provided as a courtesy based on your representations that you or that your client has authorized you to act on his or her behalf. Again, we're trying to get to the end game. We're trying to resolve this matter. So, just use a little critical thinking. Nobody's trying to hide the ball here. We're trying to resolve the case. The next couple of blurbs, I, have some legal import. I like to include them in all the letters and just state that the plan administrator responds to written document requests only as to documents encompassed by the statute, which requires the plan administrator to produce the following documents, and then list the statute as we've been talking about. The latest updated summary plan description, the latest annual report, et cetera, et cetera, et cetera. You've got that. This is what you're responding to. Then you want to say the plan administrator has not included any other information outside the scope of the statute and declines to respond to such matters. We assume that your document request refers exclusively to benefits provided under the health plan, Then you state that you believe that this letter is fully responsive to your requests under the statute, and you may contact me if you have any questions about this letter. And we talked a little bit about that too, and you can even list out if the request is in bullet point or by number, however they're sending it to you. You can say, we are not responding to this request because it's outside of the scope of the statute. Please contact me if there is any information that I can provide you. Again, trying to get to the end game. So just talking a little bit more about penalties. When the penalties are imposed, there are 5 factors that courts use to assess whether a penalty should be levied. So I think it's important to know what that looks like. And the first one is bad faith or intentional conduct of the plan administrator, like intentionally hiding the ball and not providing this information. The courts will look at the length of delay. And of course, some plaintiffs' attorneys will not even remind you about it. They would love for months and months to pass so they can say, I don't have to pay this lien because you owe $110,000 in penalties. So anyway, a court will look at the length of the delay, but a court will also look at the number of requests made. How many times did they ask for these documents and how many times were they not responded to? Were documents withheld, legitimate documents withheld? They'll take a look at that, and they'll take a look at the prejudice to the participant. And we all know that plaintiffs' attorneys can come up with a whole lot of prejudice with not a whole lot of facts, so you just want to bear that in mind. And the last little item I will mention.
I'll finish up before I interject my question.
Okay. All right. Let me finish up this little last part. Speaking of COVID, there is a disaster relief, the CARES Act, that was put into place in March of 2020. And it's notice 2020-01, a delay in responding to your request during the outbreak period, March 1st, 2020, through the 60th day following the end of the national emergency declared by President Trump on March 13th of 2020, will not violate federal law if the plan administrator acts in good faith and furnishes the SPD as soon as administratively practical under the circumstances. So this applies not only to the initial SPD that needs to be sent to plan participants, but also the plan documents. And the last little bit, as an FYI, on February 18th of 2022, President Biden formally extended the disaster relief notice that applies here. So Ryan, what's your question?
No, yeah, so this is a great template to respond, but I was wondering, just wondering aloud here is, what about these situations where, because we've got the group / plan administrator, we've got the TPA, we've got the subro vendor, there seems to be a lot of potential for these requests to fall into a black hole, dead zone, whatever, where, either one of two scenarios is the requests go to the subro vendor, and the subro vendor says, hey, we're not the plan administrator, we're not going to respond, so nothing goes out, or they go to the group and the group says, well, we've got a TPA and a subro vendor for the health plan, I'm not dealing with this stuff that has to do with a subrogation claim, and so it gets ignored. And I'm wondering, what are the recommendations for getting all of the parties on the same page so that we aren't ignoring these important requests?
Well, first thing I like to do is to ask the plaintiff's attorney, if you made a document request, please send me a copy of it. And then as soon as you have a copy of it, then you go back to wherever it was sent. You just kind of go up the line. Whoever your client is, if it's the TPA, send them a copy of that document. This is where it went, and you can kind of address it that way. That's the quickest way. You don't always get the quickest response if it was sent to PO box, whatever. But then you can also go back to the attorney and say, give them better information. I like to give them contact information if I do have a contact at the plan, to try to get those answers. Try to take care of it myself. Go directly to the plan or my client and assemble the documents and send them. Of course, immediately, to the extent that I can do it, I send them a copy of the SPD and the 5500 and get that off the Department of Labor's website. And sometimes that shuts it down right there. There's no need to provide the rest of the documents, or I specifically say, is this sufficient to, are these documents sufficient to answer your question, to address your client's questions or concerns? And the answer will be yes or no, depending on the person that you're working with. Typically, they don't like for these fights to drag on any longer than we do. So again, just try to get to the end game and get to the right document.
Awesome. Thanks, Nancy. Catherine, why don't you jump to the next slide and I'll jump in here. So really a variation on this kind of common argument is, hey, the subrogation provision can't be enforced because my client never received a copy of the SPD or plan. There's a lot of variations of that same type of argument. And there's different ways that we can address it, but I want to kind of focus on, well, what are the required technical requirements for meeting this furnishing requirement? Is there any truth to this argument that's being made? And so under ERISA, plan administrators are required to first furnish participants and beneficiaries with a copy of the SPD within 90 days of their enrollment. So that's 1024B1, where Nancy was talking about B4, which is after we've been enrolled, what are these document requests we can make. But initially, you've got the obligation to provide them with a copy of the plan. So how do plan administrators do that? So of course, we can deliver documents to participants by mail or in person at a meeting, for example, an HR training session. But I would say that in today's age, the most common practice is to do it electronically, either via the internet or some sort of an internal portal. And the ERISA regulations address this. Documents may be furnished electronically, provided that the system for doing so is reasonably calculated to ensure actual receipt of the information. But in whatever scenario the delivery occurs, you will need to make sure you understand how your group handles this issue. You'll need to really request this information during, I would say, recommend during the onboarding process, or otherwise you're going to have to end up contacting the group's HR or TPA to determine how they circulate the SPD. We've had situations where this question was not raised before the case was ready to be litigated, and then all of a sudden a case is ready to be litigated, and all these ugly issues come out, right? It's like, well, oh, we were never talking about plan delivery or furnishing during our negotiations, but now that there's litigation, you're going to get every possible defense out there. And so you go to the TPA and they say, oh yeah, we've got this great portal, right? Oh, awesome, we've got a portal. Well, what does it look like? Well, it looks like this, and here's the plan document. All right, great. Well, can you provide me the confirmation that this particular participant enrolled in the plan and then access the document? Well, no, we can't do that because we just recently posted the SPD on there. It wasn't up there before. That's a nice fact that you'd like to know. That's a good one. Try to get those in advance as opposed to finding out about them in litigation, because it makes our lives as litigators somewhat more challenging. So what does the case law say about what it means to be reasonably calculated to ensure the actual receipt of the information? Catherine, you can jump to the next slide. So I did a little digging to make sure that we've got some support on our side of what the cases say. There's not a lot of them. There's, I would say, 3 or 4 district court cases that even really touch on the subject. So I tried to highlight the ones that are at least that are important, that do. First, the documents need to be obviously available online. So that's JDA software case out of Arizona. Has some good language for us. If the employer is making it available via an internal HR portal that's accessible by everyone, all you got to do is really show that a link was provided. Great, awesome. And second, you've got to make sure that you do provide the ability for the participants to access the documents. So that may be easy for office workers who have that computer right there, but what if you're dealing with manufacturing employees or other laborers who don't have ready access? Again, really what the courts are going to be looking for is proof that you provided some sort of a link, or you provided them with access to a computer terminal to access this, or frankly, all you got to do is provide them with access to the document in the HR office. Basically, that's going to be enough to kind of meet your burden to show that you furnished it. The central states basically said the same thing. Provide that link, provide evidence of that link, and you're pretty much going to be good to go. And so that's one of the things that we'll ask for, because if we get into this back and forth with the plaintiff's counsel, we need to go back and have that email, that link. Sometimes the TPA will have the ability to print out a history of every time that the employee logged into their online account. We'll get that and we'll show it to them. That's going to be good enough. Whether it's good enough for the lawyer or the lien resolution vendor, I don't know, but it's going to be good enough for you if you've got to litigate the issue. Just like you've done, maybe familiar doing on cases where the stop loss question is being asked. You might have to provide an affidavit from the TPA or the plan sponsor to explain, walk you through how this link is generated, where the documents are stored, how an employee is able to log in. It creates an extra little burden for us, but we can do it. It just takes a little bit more extra work. So what happens if the SPD was never properly furnished in the first place, or you can't find proof of delivery? So technically you could be subject to those same statutory penalties that are available under 502C, which Nancy talked about, the 110 day max. But of course, those penalties aren't automatic. It requires that participant to actually file in federal court under 502C to bring that claim. And then obviously they've got to show bad faith, prejudice. Not always going to happen. We've seen courts impose no penalties at all, even where there was a violation. We've seen courts impose $1 a day penalty. But we don't like to get into those if we don't have to, because it can become unpredictable. So let's try to, these are issues you want to try to focus on now if you can, whether you've already done the onboarding or not. Go back and see if you've got issues related to plan furnishing or document issues. Even if they're not up front and center of your current negotiations. These are things you want to just kind of have tied down so you don't have to worry about them later on. I'm going to see if we've got some, we do have some questions about whether the PowerPoint will be made available. Anyone who wants it, just email us. We'll send you a copy. Not a problem. If you've got any questions or you want some additional case law on these, let me know. We couldn't throw it all in there, but we've got some else that we can share. And again, thanks again for joining us. Feel free to go on the website and download other sessions or email us questions. We'll answer them right away. But turning to next month, to just kind of preview next month's webinar, join us Tuesday, so last third week in the month or whatever, May 24th. We'll be discussing the post-Montanil issues. So disbursement, dissipation, commingling. What does that all mean? What's the difference between dissipation and disbursement? How do we handle, practically speaking, going after funds that have been dispersed? We'll talk about all those issues. We'll highlight the cases that have come out post-Montanil, dealing with those issues. And we'll also then pivot after we touch on that to basically a primer on stop loss coverage and how it impacts the day-to-day of handling a subrogation claim. So join us then. Until then, feel free to hit us with questions. Good to see you all virtually again, and we'll see you next month.